The discovery process, we always begin with the family. I mean, fundamentally, we need to understand who makes up that family. So if we have a look here, we've got Bill and Mary. And Bill and Mary have got 3 children, Jim, John and Karen. Jim is married to Sue. Karen is in a relationship with Jack, and John is single. I've put an asterisk there because through our discussions we've identified that John is what I would call a vulnerable beneficiary. Bill and Mary, through difficult conversations, have acknowledged that he has a drug dependency. So when we're talking about estate planning, we always need to be mindful of that and how best to plan for John's future needs. So as you can see, this is a typical family scenario. We know in Australia today that roughly 1 in 2 relationships don't last longer term. So what's the implications to the family, to the estate? We need to talk about these things. And one of the other issues that has been uncovered is that Jim and Sue are currently seeking some marriage counselling. In other words, they're going through difficult times. And that is of concern to Bill and Mary, because what happens to their estate if it's left to Jim, should Jim and Sue part their ways? So these are the types of areas that we really need to flesh out with clients to understand their family dynamics, previous marriages, any vulnerabilities to the children, such as drug dependencies, or you may be surprised how many children may have a disability that we need to factor in as well. The purpose of collecting someone's asset position is to understand the entire estate. So what we want to know is what is the asset, importantly who owns the asset, the approximate value of that asset, and is it encumbered by any debt. They're the 4 basic things that we need to know. A lot of people have the notion that if they have a will, it will automatically deal with all the assets that they have in their estate. Well, this is not quite true, because what we need to identify in the owner column is what is an estatable asset and what is a non-estatable asset. In other words, what will flow directly to the will and what may not. So where we see assets owned individually, so for example the family home is in Mary's name, that would form part of Mary's estate. We see they've got an investment property which is held via a family trust, which is very common. Businesses run via trusts, investment properties and so forth. Family trusts or trust assets don't automatically link to the estate. And typically what we do is, when we understand there's a family trust, the first question that comes to mind is who are the trustees? So in this case, if the trustees are Bill and Mary, typically if something were to happen to Mary, Bill would assume control or vice versa. However, what happens if something happens to both Bill and Mary? How do we ensure that what's been accumulated in that trust ends up in the right hands? And through estate planning, we have to link the trust to the estate via the will, by having what we call succession of appointor. Look, it's a very good question. Estate planning can mean many things. I try and keep it simple. And for me, first and foremost, I need to establish what's most important to people, what keeps them awake at night. That's fundamentally where I start. The next thing is to understand what are the right assets. What do people own? Because what we want to make sure is that the right assets go to the right people, which is invariably family members, and also at the right time, which I'm going to talk about in a moment. And that is in essence what estate planning is about. But before we can move into solution mode, we need to understand the family dynamics, the assets, the entities, any business. You know, we've acknowledged here that Bill is in an accounting firm and a 50% partner. So what is the implications if something happens to Bill in relation to his share of the accountancy firm? So what I mean by the right time is, first of all, we've got to make sure that the assets go to the right people. So in the event of Bill's death, we want to make sure that everything goes to Bill's estate. And furthermore, once it reaches Bill's estate, let's say for example that everything's to go to Mary, then we need to make sure that whatever's left to Mary, should something happen to Mary, ends up in the right hands at the right time. So what we do is, if I use triangles here to represent trusts, I want to identify what we call the lineage, which is the family members, the bloodline. And if we have a look at this, which is Bill and Mary's estate, what you can start to see is that there's this bloodline. And what we want to always make sure is that the estate cascades from one generation to the next. So, right time, what do I mean? If Bill and Mary died and the funds go direct to the children, are they in a position to make the most appropriate financial decisions for their future? Jim is married. Jim is a sound mind, has a steady job, married to Sue, there's a couple of kids. We did identify though there's some marriage implications. However, because he's an adult, the funds would flow through to Jim. And what we'd be encouraging Jim to do is to hold what's left by Bill and Mary in trust. Loosely, why do we do that? We always want to protect the estate from what I would broadly say are predators and creditors. Now, creditors could be people we owe money, such as banks. Predators may be former spouses. And we always need to take this into consideration, that if Sue and Jim went their own way, do Bill and Mary want to ensure what they've left Jim remains in Jim's hands and ultimately their two grandchildren, Liam and Jane? So we need to do careful planning. If we look at John, the right time for John would not be now. Bill and Mary have let their heart flow and shared the fact that their son John is a drug addict. Would it be appropriate for John to receive, for example, 1/3 of the estate with a drug dependency? Well, the answer is obviously no. So what we need to do for John needs to have a trustee. And that trustee needs to look after his financial well-being, because it's not just predators and creditors, it could be John harming himself due to his vulnerability in relation to drugs. So it's very important from a timing point of view that John not actually have access directly to what's been left him, but he has to go via a trustee who's got his best interests at heart. So superannuation's an interesting area, and as we know, Bill and Mary have their own self-managed super fund and have accumulated quite a bit of wealth. What they would like is ultimately what's accumulated in superannuation to go via their estate and distributed according to their will, should something happen to both of them. So what we need to do is make sure that we're working with their financial planner to put in place an appropriate beneficiary nomination. And typically we have what's called a binding death benefit nomination to the legal personal representative. In other words, it goes via the will and is distributed there. And again, all ends up in the one bucket should something happen to both Bill and Mary. If something happened to just Bill, then Mary may need the flexibility to maintain her superannuation within the fund for pension reasons. So we need to, this is where we take this collaborative approach where we talk with the financial planner or the accountant or whoever's involved with their superannuation to collectively come up with the best outcome. The next area, which is really important, is reviewing of entities. Well, we know that they have a family trust. We know that Bill's in partnership, and we know that they have a self-managed super fund. So immediately what that tells me is we need to obtain any trust deeds, any variations to those deeds, any partnership agreements, and we need to review those. We need to make sure the trust deeds are up to date. Legally, they stack up. But importantly, we need to know who the trustees, so we can link the succession via their wills, as I mentioned before. And as far as partnership as well, we need to know, well, how is that entity held? Is it via a trust? Is it via a company? Is there a partnership agreement in place? Is there a succession agreement? These are the sorts of things we need to extract out, gather all this information so we can put appropriate plans in place. The next area is, of course, well, once we've done all this, where do you keep your documents? Do you have a secure storage facility? It amazes me how many clients don't, how many clients lose their wills. Well, if you die and the original will cannot be located, you throw your estate into disarray. So it's very important to not only do it properly, but to store it and store it securely. And furthermore, where is it actually held? So we help clients with that. We help them with what I call a letter of wishes. So very simply, the will dictates what must happen legally. The letter of wishes, which accompanies the will, is the why certain things have occurred, why we want a particular asset to go to a particular child. That way it's all about communication. That letter of wishes, while it's not a legal document, can continue to be evolved over time and is very emotive and very powerful. And I'm a great believer in having one, and we help clients create and maintain a relevant letter of wishes. Education material. People leave my office and they're thinking, what was he talking about, living wills? Well, we send them the appropriate education content so they can digest it over time. Because as we're taking them through our estate process, they're being educated and they're learning on the way so they can make really appropriate decisions. Finally, one of the things that we do, this discovery process which takes an hour with clients, is at no cost. And the reason for that is I need to understand someone's affairs intimately before I can establish how or if I can help them. Furthermore, we provide a fixed price package. In other words, we scope out the gaps, what's required. We provide one cost to get a client from A to B, to take them through the estate planning process, which is invariably 3 months. And if they see value in what we're offering, we proceed. If they don't, well, we've had an enjoyable hour together.